civil rights overall. So a little bit about Eastern State. We are a historic site. We're the nation's first penitentiary. It's not an active penitentiary, but now a museum and an educational institution to teach all about justice in America and really ask ourselves this question of how do we engage with justice and what is meant by the prison system. This new series is Justice 101, and it is about exploring the justice system in America from the founding to today and its impact that it has on our society, our citizens, and our world. Today's program is just the beginning, so we encourage you to reach out and find out more at easternstate.org. Now, for today's topic, I have two fantastic speakers with me. Let me do quick, brief bios, and I'll let you join in and share a little bit more about yourselves before we kick it off. So David Rudovsky is one of the nation's leading civil rights and criminal defense attorneys. He practices public interest law, and he is also a senior fellow at the Penn University Carey Law School. He teaches courses like criminal law, constitutional criminal procedures, and evidence. He's also a co-author of Police Misconduct, Law and Litigation, and the Law of Arrest, Search, and Seizure in Pennsylvania. We also have Vince Warren. Vince Warren is a leading expert in racial injustice and discriminatory policing, and is the executive director for the Center of Constitutional Rights. He oversees the organization's groundbreaking litigation and advocacy work. Under his leadership, the Center for Constitutional Rights successfully challenges the NYPD's stop-and-frisk policy and profiling on Muslims, ending long-term solitary confinement in California's Pelican Bay prison, and establish the persecution of LGBTQIA as a crime against humanity. Welcome to you both. Thank you so much for being here.
Good to be here. Thanks.
So I figured we'd start off, Vince, if we're talking about the Fourth Amendment, I think it's very important that we begin with the actual Fourth Amendment. So I'm going to read it really quickly, but then I'd love to ask you both to share a little bit about how you came to this practice of studying the Fourth Amendment of our Constitution, and a little of the work that you're doing today that implies the action of the Fourth Amendment in our lives today. So let me read the fourth. You know, my role is always to bring us closer to primary sources, if they're people, if they're cases, or if they're actually the Constitution. So here's the fourth. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall be issued but upon probable cause, supported by oath or affirmation, and particularly describing place to be searched and the persons or things to be seized. So let me turn it over to you, David, first. Could you tell us a little bit about why you study the Fourth and your work in this today?
Yeah, for sure. So I started my practice as a public defender in Philadelphia in 1967. And representing persons accused of crime, the Fourth Amendment became a primary instrument I had to deal with because it governs when the police can stop somebody, when they can frisk them, when they can arrest them, when they can search them, all of which leads to a prosecution. And the point about the Fourth Amendment generally is that the police can only interfere with one's liberty and freedom of movement if they have probable cause to believe that somebody has committed a crime or is about to commit a crime. And in many cases, they first need permission from a judge, a search warrant or an arrest warrant, to get involved in a particular investigation. We're going to talk about stop and frisk, where in the 1960s, in 1968, the Supreme Court for the first time said people could be stopped and frisked somewhat short of an arrest on less than probable cause, what the court called reasonable suspicion, which lowered the threshold for police conduct and was part of a kind of new movement for proactive policing. In my practice, first as a public defender and now as a criminal defense lawyer and civil rights lawyer, that has been a major issue for our office, for our clients. As Vince and I will talk about, millions of people since 1968 have been stopped on less than probable cause, have been frisked, most of whom are completely innocent. In Philadelphia, over 90% of all the people stopped are completely innocent. There are huge racial disparities in the way the police use this tool, as reflects in much criminal investigation work. And as you'll hear, both Vince and I have handled cases in which we've challenged broadly the power of the local police to do so, and we can talk about that.
Wonderful. Thank you so much. And Vince, to you.
Thank you so much, Curry, and it's great to be with you, David. Thank you, Eastern State, for inviting me. Also, for those playing at home, my former boss, but current mentor and current friend, Steve Shapiro, is on the call. And students, if you can get a mentor, boss, and friend combo together, that is a very, very good thing. You're winning. So I feel like I'm winning. I actually also started as a public defender in Brooklyn, in New York, and that was really where I began to sort of understand the relationship, particularly between police and poor people. Legal aid, represents folks who don't otherwise have the ability to afford an attorney, and so we're amongst the lawyers that are assigned to them. And the Fourth Amendment, particularly around not sometimes around homes and places that are searched for which you would need a warrant, but I think also in terms of street level stops, which David was also talking about. How do it raises the question that if you've got someone that has been stopped and they've been searched and there were drugs or guns or something illegal that was found on them and they get prosecuted, when you get to court, you actually get to test whether the search that led to the seizure of those of that contraband was actually done correctly and done in meaningful ways. And so it really can operate as a check on police power. They just can't stop you for any reason they want, of course, unless they do, which is usually when David and the ACLU and the Center for Constitutional Rights starts filing cases. But it's a key provision of our constitutional rights, and it should function in its best form as a way to protect us from just randomly being approached by law enforcement and them saying, empty your pockets. And then if they find something on you, then you're off to the races.
So I'm going to do a framing question, and then I want to dive into this because there, with so much with the Constitution, we talk about like there's a lot of gray there, or what one of my favorite constitutional scholars always says, it's complicated because it's not always an easy yes or no. It's always by case scenario. It's always by this moment. What are the different factors, which makes it, I think, the Fourth Amendment such an interesting thing to explore and examine because it's constantly shifting in our society and it shifts with technology. But when we think about that original constitutional amendment that was added to the Constitution right after ratification, so I think it's 1791, if I get the year right, around that year. When we think about that, what's the purpose of the Fourth Amendment and overall the Bill of Rights? What is it to establish? What is the fear that Mason and others and Madison have and want to really get these amendments into the Constitution? Because I think that framing helps us understand the perspective that we talk about the Fourth Amendment today and why it's set the way it is in our society.
Yeah.
Either one of you can dive in on this one.
I'll start and Vince will pick up. Very hard to map on what the framers of the Fourth Amendment in 1791 were thinking about in terms of 2024. There were no organized police forces in America. We had just the beginning of a criminal justice system which took many, many decades to form. But what was clear in the minds of those who were drafting the Fourth Amendment, indeed the whole Bill of Rights that was drafted, the First Amendment, Eighth Amendment, Sixth Amendment, and so on, was to put limits on governmental power. That was the basic message of all those amendments. And in particular, the Fourth Amendment, the colonists had gone through many years of random searches, arbitrary searches by the English government, because there was widespread violation in the colonies of the tariff and taxing laws. Britain, tried to keep all the trade for itself, and there were huge tariffs on trade with other places, which the colonists were breaking. And what the British did in terms of law enforcement with the colonies was use what was called a writ of assistance, which was like a search warrant that allowed authorities to enter your home or business at any time for any reason. for months or years at a time. Um, that was challenged by James Otis. There was a famous court case, and there's a great line attributed to that. While he lost, this was in the 1760s. It was labeled as the first shot in the revolution. Right? I mean, there was so much anger at what the British were doing that it was no surprise that when the Bill of Rights was drafted, it would include a Fourth Amendment, as you've read, which requires, when you read it, the police to have a certain level of cause before they interfere with your freedom, and in many cases, seek permission from a judge first, and then we've seen exclude the evidence if you violate that. I think that Vince should fill it in, and then we can talk about the progression from that point to the 1968 and the Terry case, which again kind of reduced the protections that were there. For the first time, said you could interfere with somebody on less than probable cause. But Vince, why don't you pick up on that as well?
Yeah, so it's just a few things to add, and I would love for you to set up Terry for us, David. I think, Curry, it's a great framing question, and I think there are certain things that don't happen or shouldn't happen that sort of that we kind of think of sort of the floor of what it's like to live in the United States. And so one of those things is that the government just can't bust into your house anytime that they feel like it for no reason and say, wow, look what I found. Either I'm going to take it or we're going to confiscate it and we're going to prosecute you. And it was, I was going to call it the Wild West, but I guess it was before the Wild West. That what those provisions were pushing back against was exactly what David said, and it actually has worked because I think most of us can say that we feel secure in our homes and our effects from that level of intrusion. Just, any old time that we want to come in, we're going to come in. I think where as David started out by saying that it's challenging to map 1791 to 2024, and I think it's precisely because that society has evolved. We now have a police power that is organized and that has objectives with relation to law enforcement, and that there are really interesting things that happen. So you can map on how in poor communities, policing works differently than it does in affluent communities. In Black and brown communities, it works differently than it does in white communities. And so I think, as we think about the modern era of the Fourth Amendment, that we're pushing back against something different than I think we were pushing back in the Constitution. We were actually looking for the question of how fairly and equitably this wonderful amendment is applied and whether it's applied in certain circumstances and how it's applied. And I think most importantly, as David's going to talk about, how it gets watered down, in my view, to account for an increased sense of that law enforcement needs more power vis-a-vis people than certainly was the case when the Fourth Amendment was ratified.
And I think that's really important too, because if we're talking about these constitutional framing and these constitutional framework that we live by, a part of the agreement of that framing is a rule of law, which is equally applied and transparent. And that information is shared. So it really helps kind of set like, this is what's written, and then how do we see it actually apply? So that, in David, you've mentioned this twice now, it starts to shift. Questionable how it was applied before and if it was fair or equal. I'm not saying before the shift it was done perfectly well. I just want to be real transparent with that. But we start to see a shift and we get the big key court case, Terry v. Ohio. So can you kind of walk us through what happened during the Terry case? And then, both of you really let us know how that applies to us today and how our interaction with police officers is shifted because of that Terry case.
Yeah, sure. That was and this was actually during the 1960s in the Warren Court, which was heavily criticized for, a lot of people said, favoring the rights of criminal suspects over the police. Nixon ran against the Warren Court in 1968. But in fact, during that period of time, while they certainly did expand rights generally, First Amendment, racial fairness and equality, and some liberty rights, they also were attuned to what the police wanted to do. And you also had by the 1960s for sure, even before, as Vince said, organized police forces, 18,000 police forces across the United States, federal, state, local, hundreds of thousands of police officers involved. And you're starting a war on drugs and a war on crime in the late 60s and 70s. And so there's a big political shift as well. And what the police started to push for and what they were doing generally under vagrancy laws and loitering laws and so on were to stop people before a crime was even committed on the theory that they're going to interfere and stop somebody before they're about to commit a crime, right? Which is different from the probable cause that somebody has already committed the crime, right? A lot of police would react to a report of a crime and investigate it, and if they found enough information, they could arrest somebody and search them. Now they were pushing for the power, and it was the Terry case that gave them that power in 1968 to stop somebody and perhaps frisk them on less than probable cause. And probable cause wasn't much to begin with. Maybe a 30% chance, 35% chance of finding something, which even there it meant a lot of innocent people could be stopped. So briefly, in Terry, this was a case where an experienced police officer in San Francisco was observing some men, three men, who seemed to be casing a store, casing in the sense of looking inside, walking up and down the street, talking to each other, as if they were possibly planning, a robbery in that store. Now, they could have been doing a lot of things. They could have been waiting for their friends. They could have been window shopping. They could have been discussing where to have dinner, right? The conduct itself didn't give probable cause that they had committed the crime or was about to commit one. But in the officer's view, it looked very suspicious. And so he immediately went up to them at some point, told them to stop. And because it looked like it might be a robbery, thought they might be armed, he frisked them. And on one of them found a firearm. That person was charged, convicted, and then took an appeal to the Supreme Court saying the Fourth Amendment requires probable cause. You can't water it down to something less than probable cause, this so-called reasonable suspicion. And again, this quote liberal court, Chief Justice Warren wrote the opinion, and it was an 8-1 opinion upholding the right of the police to stop and frisk in that kind of situation. Only Justice Douglas dissented from that opinion. Now, the opinion was somewhat narrow. It was somewhat limited in many ways. This was a serious crime. It wasn't just any offense that somebody might be committing. If the officer was right in his suspicions and his inferences, the persons might be armed, and that's what seemed to drive the case. The court noted, remember this is 1968, huge racial disturbances in the United States, movements for equality. The background when they decided it, that was the same year that both Martin Luther King and Robert Kennedy had been shot and killed by armed assailants, and a very strong political movement to give the police more power, right, to deal with disturbances, to deal with what seemed to be a rising number of violent crimes. All of that fed into that decision for sure. I mean, the court recognized that this could be create racial problems, recognized that a lot of innocent people would be stopped, but they said that's a cost they were willing to bear. Now, what will happen, I'll let Vince fill in as well, in the years that immediately followed, you had a much more conservative court, and they expanded stop and frisk to any offense, even the most minor offenses, jaywalking. Somebody could be stopped. And if the police, for some reason, thought they were armed, they could be frisked. So it gave the police, in many ways, an open door to stopping people, investigating them, and led ultimately to litigation that Vince had in New York City, the Floyd case, and we have in Philadelphia, in Bailey, when it turned out in these situations, when we finally got good data on what they were doing, at one point, the New York City police in the 2000s were stopping 700,000 people a year in New York. In Philadelphia, they were stopping at the same time 260,000 civilians a year, pedestrians, equal number of car stops. Actually, in Philadelphia, with one-fifth of the population, they were per capita stopping more than they were in New York. And once we started to look at those large numbers of cases, what we found is that a huge number were without even the reasonable suspicion that the court required, huge racial disparities, and a very minimal hit rate. It took hundreds of frisks to find a single gun, which meant this was just kind of random policing. But I don't want to get too far ahead. I think Vince would have more to say about Terry and the post-Terry developments in terms of the war on drugs and policing in America.
Thank you. Yeah, and so yeah, I'm going to sort of move it from there. I do want to sort of take um, a couple of steps back before I go into the stop and frisk thing. One step back that I want to take is that there's an interesting element about how most people think about the Fourth Amendment. And so when we laid out what it was designed to do, I mean, virtually nobody can disagree with that, right? The British shouldn't come in and with all of their shenanigans. But you know, David started talking about the war on poverty, the war on drugs, the war on crime, which happened in the 1960s through the 1970s. And what that did was that shifted public sentiment towards the idea that there are crimes that need to be solved, and so that we should give the police more power to solve them, mostly by virtue of the framing by law enforcement that this is a war on those things. The second thing that it did was very much like wars on anything do. You're not actually fighting the actual crime. What you're doing is you're using people or a population as a proxy for a crime. And what I mean by that is when we're talking about a war on poverty, we know where the poor people live. And of course, there's going to be more open criminal conduct in those impoverished communities. We also know that in Black and brown communities that these things happen. And if you think about the war on terror, then we're talking about Muslim communities. And so that one lesson around the Fourth Amendment, from my perspective, is that when the government declares war on something, they're actually declaring war on people. And so that sort of brings us to the Fourth Amendment piece. The other thing I want to say about the Fourth Amendment is that it can work beautifully on paper when you read these cases. But let me give you a sort of a typical example of what it's like in practice. So after Terry, the police would have to demonstrate a reasonable suspicion that crime would be afoot. My favorite pieces of this in the law is the anatomical pieces of it. So crime either needs to be afoot or crime needs to be at hand. But at any rate, it has to be reasonable, which in New York was interpreted as any reason that a police officer can give for this, which is a super, super low standard. But as a practical matter, that gives law enforcement more flexibility, and it restricts the flexibility of people that are subject to stops and subject to subsequent searches and seizures. An example of that would be, if you can imagine being in the Bronx or being, in Frankfurt, and a police officer comes up to you and says, "Hey, get on the ground," and you say, "Excuse me, officer, I would just like to know what's the reason by which you are stopping me in the first place, because I was just going to the store to get milk, and asking and seizing me by telling me to get on the ground." The way that the law has now been interpreted in police rights is that police will very often see non-compliance with what they think of at the time as a lawful order as an escalation in violence. So that allows them to use more force against you. So if you don't get on the ground immediately, then they're using more and more force against you. So if the police officer said, "I need you to do the hokey pokey right now," and you're like, "Are you out of your mind? Why should I do that?" If they think that's a lawful order, next thing you know, you're against the police car in handcuffs. And even if they don't find anything on you, you can catch resisting arrest charge, or whatever the equivalents are in Pennsylvania. So exerting asserting, excuse me, your rights under the Fourth Amendment can be a risky endeavor for people in particularly Black, brown, and marginalized communities. And so what we saw in New York, as David was pointing out, is that the number of stops that, and sorry, the number of stops and frisks that were happening in New York skyrocketed in New York City in the post 9/11 period, interestingly enough, because there was a ton of federal money that was coming in, post 9/11 money that was supposed to be looking for terrorists, and a lot of that money went to the police department, and the police department's like, wow, we can actually solve two problems, the war on terror and the war on crime. And but it did manifest mostly around Black and brown folks. And so the way that it played out was that, according to our data, and there's a whole, I'm a justice guy and I'm not a data nerd, but you can't get to the justice thing without the data nerd piece. David's nodding. The data was showing through the litigation that we were having that 87% of the stops and the frisks that were happening in New York were against Black and brown people, and that they were way higher than obviously white people. And then for folks that say, well, I mean, that stands to reason because aren't Black people more likely to commit crimes than white people? By the way, the answer to that is no. So fight back at your kitchen tables if somebody's trying to pull that off. But the answer is no. But what ended up happening was that police were stopping Black people more than white people, regardless of whether it was a predominantly Black neighborhood, a predominantly white neighborhood, or a mixed neighborhood. They were stopping more Black people than white people, whether it was in an economically disadvantaged neighborhood, a middle income neighborhood, or a affluent neighborhood. So no matter what was happening, they were stopping in Black and brown people more. As David pointed out, that the vast majority, over 90% of the people that were stopped had no contraband on them. Stop and frisk was touted as a way to get guns and drugs off the street. And when you looked at the data, with the hundreds and thousands of millions of stops, the percentage of contraband that they got was 0.01% of all of those stops. And so if you think about it as if you were selling a business and you say, great, you know what, I'm actually wrong 92% of the time, but you should invest in this business. It's a terrible investment. But yet this was the investment that we were doing in our neighborhood. So we filed litigation against the New York City Police Department, and we had a 13-week trial in which we basically put this data and the police justification on trial. Just on the point of solving for crimes versus solving for race, as I was mentioning, that this program did not solve for crime at all, and it really swept up a lot of innocent people. The other piece that was important was that the police department's own protocols were actually using race as a proxy. So there was one sergeant or lieutenant in the 41st precinct in the Bronx that said, your job is to arrest male Blacks ages 14 to 21, I think it might have been. And so the idea was that it was targeting Black folks in that age range because they were saying that the likelihood that they were going to get something was greater. So you can't have a reasonable individualized suspicion that something is about to happen if you've got a citywide mandate, or at least a precinct-wide mandate, just to stop all the young Black men. So there was evidence like that that ultimately persuaded the judge, not that stop and frisk is unconstitutional, because the Supreme Court has said that it is, but the policy and practice, the way that the New York City Police Department was doing it was unconstitutional. And so that's, one of the ways to think about that endeavor is to say that it is a way without a constitutional convention to refill in some of the holes that were scooped out over the previous 50 years, at least for this particular police department. And the Philly Police Department and the New York City Police Department are deeply significant nationally. They are places where that set national trends for how police officers operate. So having challenges in these particular jurisdictions that really center the experience of the people that are being stopped and frisked and looking at the policies and practices of the police can be a significant way to think about reform, because it does create disincentives for police officers and police departments to be tempted to go back to the 1790 eras where Black people were not full people, and governments could just stop people randomly because they felt like it.
Yeah, and let me just map onto
Go
that.
right ahead.
So that Philadelphia, because we followed New York, that Floyd case was filed. We had a similar situation in Philadelphia where there was a huge increase in stops um, by the police in the 2008 to 2010 era. We started to get huge numbers of complaints from people who were stopped repeatedly for no reason. We filed a lawsuit, and the city, as opposed to New York, looked at it and said, we can't defend this lawsuit. And they reached out, and we got what was called a consent decree, where they agreed, not to stop people without reasonable suspicion, to stop people without race being a factor in the stop, appointed a monitor. We monitored the case. They agreed to, and this was critical when we talk about data. Remember, the only cases that judges ever saw in this situation was where something was found. So if an officer stopped 100 people and found a gun on one of them, right? Wrong 99% of the time, right 1%, that's the case the judge saw. And the judge thought, boy, this cop's got a sixth sense. He knows when to stop somebody for a gun, because the other cases weren't even being recorded in many places. So in Philadelphia, New York, we had an electronic database of every stop, every officer. Philadelphia had a form that required the police to state the reason for the stop and the frisk, so we could challenge that. And once we started to monitor this, we found exactly what the judge found in New York. The great majority of stops were without reasonable suspicion, even if you believe what the officer wrote, and even with a reduced standard. People were being stopped because, quote, he looked suspicious, right? He started to walk away from me when I approached him. He wouldn't take his hands out of his pocket, that kind of thing, just like Vince said. Huge racial disparities as well. And on that, there's more crime in Black neighborhoods and poor neighborhoods. What do you expect? We have more police there. We had some benchmarks. And the most interesting one was when we compared stops without reason by race, right? Where both we and the police auditors agreed that what the officer did was improper under the Fourth Amendment because they didn't have reasonable suspicion. There were many more of those minorities, Blacks and Latinos, than they were of whites. And so that was kind of a benchmark that addressed the police version. Even with all that, in Philadelphia, it's taken about 14 years, but a huge change in public opinion, as in New York. And that's why I say the politics of this is important as the law. We had a progressive district attorney elected, Larry Krasner, in 2017, a mayor who was against stop and frisk practices in 2015. Once they came into office, we saw much more compliance with the Fourth Amendment. We've seen reductions in racial disparities, and most important, a huge drop in the number of stops. From 260,000 to pre-pandemic, it was down below 100,000. Now, maybe the police weren't reporting some, but they were reduced. And significantly, from the police point of view, better stops and more fines. Still very low in terms of drugs or guns, but some improvement. So it actually showed the system could respond, not fully. And when you look across the country, every city that has examined this with big data has come to the same conclusion.
This is fantastic. Very, very interesting. We're getting all those interesting comments in the chat. And actually, my job is so easy. All I have to do is listen today. Thank you so much. I just want to echo a couple things that you walked us through there, both of you. One, I appreciate the shout out for big data, that the only way we do our work well is actually to do the math and to look at the data. But also, David, to your point, you have to have the data to be able to look at it and examine. And so much in the field of law enforcement is just starting to get on the tracking of that data information. So really important. And for our younger students out there, as well as our older, math matters, and please study it. It's a great field to go into, and it works really well. Two, really fascinating that the increase, what starts these waves in our societies, and we look at crime and punishment in our society, and we looked at the impact that we have on mass incarceration, which we talk about all the time at Eastern State, because that is our mission, to understand not just mass incarceration, incarceration overall, and the reform, but how when crime goes up, the overextension of power towards organizations in the justice system like police, but also other orgs like the FBI, also increases, and also the money. So all these pieces are coming at once. And what we don't see on the way back was one of my key questions is, with all of this, are we safer? And we are not seeing that as a safer institution. We're not seeing that return on investment in that measurement practice around this. The question I have, because we talk about this, and Vince, thanks so much for pointing out, like, you can't just say, I know my Fourth Amendment rights, you can't do this. That is not going to put you in a safe situation. And for some people, especially people in the Black and Brown community, it is a very dangerous situation that you could be put into. But not everybody has the support and the financial power to push back and fight back. So if it's not really seeing a safer society, are we seeing a direct impact between the rise of incarceration rates directly correlated? And I don't know, this might be a jump, but can you directly correlate it to the stop and frisk policies that we're seeing too many people wrongfully incarcerated or incarcerated for the wrong reasons? Can we see a direct correlation between those two pieces?
I mean, I think I would put it differently. I would not say that the data would show, in terms of the data that we collected around stop and frisk, that it wouldn't necessarily map onto large increases in and of itself in the number of incarcerated people. But I think there's an element of it that I think is really key when you look at sort of non-contraband cases in particular, and how police shows up, that we're incarcerating too many people for low-level social violations, which, what I would call it. So I think it maps on almost by looking at the non-contraband aspects, because people do end up in jail because of the police encounter, even if there isn't contraband that's found on them. So I think that's kind of a key piece. The other thing that I would say, just in terms of are we safer, is that the data is also really interesting because it shows that what the national and local trends are on crime do not correspond almost whatsoever to what the law enforcement is saying about it. So just, hat tip to our friends at the Juvenile Law Center in Philadelphia. Students, check them out. They are really super awesome. And what they've been telling people since 1990s was that juvenile crime had been going down at the same time that nationally, under the crime bill, there was tons of money that was being pumped in. And it's similar with respect to stop and frisk. And so there's a little trick, a little data trick that law enforcement does, and this can happen on the terrorism lens, it can happen in stop and frisk, is that when we say, why do you have this ridiculous policy that's sweeping people up because the crime rate is going down, they say, well, the crime rate is going down because we have this ridiculous policy. And so there's that happens. And Mayor Bloomberg was the mayor at the time when, after we won the stop and frisk case after trial, sent out trial balloons of dire warnings that crime was going to go up and New Yorkers weren't going to be safe. And literally the crime rate kept going down after they changed their stop and frisk policies. So in some level, I would say that the policies, these sort of broad policies, actually do not make us safer. And that if we spent more time looking at what people need to be safe in their communities, which most Black and Brown people would not say is more police, it would be, we need jobs, we need security, we need healthcare, we need all those sorts of things, the social and economic rights that BTW, our wonderful Constitution, does not provide for. If we were focusing on those issues rather than these war on crime issues programs, we could be a lot safer than we are right now.
Wonderful. And I'm going to run through some questions that we have in the chat and the Q&A, because I promised that we would let people ask questions too, not just me. So there was a lot of questions. Warren asked a question about police stops and ticketing stops. And there was a couple other questions about in a car and the right to be stopped in a car? How does that fall under the Fourth Amendment? How does that stop with search and seizure and stop and frisk? So Warren's question was about the traffic ticket warrants a la Ferguson. So could you share a little bit about police stops in a car? And then I want to talk a little bit about the papers. We don't carry papers around anymore. We don't even have papers in my house, to be honest with you. I just have laptops and phones. So maybe we can get into a little bit of Carpenter too. Sorry, I'm going to try to jam everything in here, and then I have a data question from everybody too.
Yeah, so
Go for it. Whoever wants to
let me
dive
start
into it.
quickly on cars, because that's the opposite side of the coin. At the same time in Philadelphia, for example, they were stopping 260,000 pedestrians. They were stopping, that number of cars as well. And what was interesting, when we started to look at car stops, which started to go up as pedestrian stops went down because the police started to focus other ways where the courts hadn't yet addressed it. At least in Philadelphia, what we found is that over 90% of the stops, 90% of the stops were not for serious traffic violations, speeding, going through a stop sign, something that was dangerous to the public. It was a single light out, it was an expired registration, it was too dark shading on the windows. I mean, the police have a book, they could stop you. I have a police friend who said, if you let me follow a car for 7 blocks in Philadelphia, I'll find a reason to stop that car, right? There'll be some reason to stop it. And most of those were pretext stops. They were done not because the police were going to give a ticket, in most cases they didn't. It was only to try to get into the car, either by plain view, by consent, by persuading somebody to let the police search. Completely pretextual and often based on race. And ultimately, the Supreme Court, incredibly enough, said even if the stop was based on racial bias, that is, a black person was stopped where a white person would not have been, in a case where there were 4 young black kids in a late model car in Washington, D.C., and stopped by narcotics officers, as long as the police can convince a judge they have probable cause, often by making up a story, that they went through a stop sign, that stop was legitimate. And so the court really legitimized, right, these pretext stops in cars. And let me just tell you about the response here in Philadelphia, which was the same as we saw with stop and frisk and of pedestrians. We now have a situation in Philadelphia where City Council passed an ordinance that said police who see these minor violations, expired license, a single light out, not a dangerous situation to pedestrians or other cars, cannot stop the car. They can send a warning in the mail, they can get the license plate number and send a warning, and so it kind of lowered the footprint. At the same time, the city agreed in our litigation that for what I call quality of life pedestrian offenses, somebody's got an open liquor container, a small amount of marijuana, standing on a corner, the police can no longer stop them by an order of the court. They should tell the person to move on, right? That deals with the problem. And only if they don't move on can you stop them. And we've been monitoring that for the past couple of years, and there have been tens of thousands of those situations, and almost none where the person did move on. So we've reduced the police footprint that way, and avoided these kind of unnecessary stops, which just shows that if you focus on it, if the politics are the correct way, right, and you have leaders who are willing to push back against the police, there are some improvements that can be made.
Fantastic. And Vince, can you talk a little bit about cell phones? Because if you are stopped, does the police have the right to take your cell phone and to start going through it? A little bit of context around the stop, the frisk. What can they seize? I mean, by stopping you in some way, they're seizing your body, even if it's for a temporary period of time. But can you talk a little bit about that?
Yeah, actually, I mean, I would love it if David probably knows more about it than I would. I actually wanted to respond to another question.
Sure.
If I could. I think somebody raised a question about St. Louis. Right. And so in St. Louis, we have a case that we filed in St. Louis where they would issue these directives called wanteds, and this is totally police department issued, almost like an Old West wanted poster. These are people that we think may have been involved in something. And the process was that it would be distributed to local police in surrounding counties in St. Louis, as well as within that county. And any police officer that received that would just pick the person up and throw him in the car and then put him in detention until the police people could ask. And what's key about this is that I didn't say that they had a warrant. They didn't have an arrest warrant. If there's an arrest warrant, then things like that are more likely to pass constitutional muster. But this is literally them just sort of saying this person is wanted without any judicial imprimatur on that decision. So, so that's what was happening. We've been challenging that practice in St. Louis, and I would just sort of put that back up in the context of how the law, so how practice evolves. And I think that police departments are getting much, I would say, craftier about ways of doing this. And I think also, quite honestly, in places like St. Louis, where the civil rights bar may not be as strong as in Philadelphia or New York, that very often police departments will try stuff in other places. We're seeing this in the Midwest that they wouldn't necessarily try in places where kind of the lawyers hang out. So it's a national challenge that I think in different state and even city contexts can look very, very different.
One more question on that before we jump back to Carpenter around that. What keeps the eye on the prize when to ensure that we're applying our laws fairly and equally? So often when we talk in this program, we talk about the role of the person, of all the people, not just the legal team and not just the lawyers, but what's the role of all of us to make sure that if we are living in St. Louis or other locations, that we're advocating for appropriate, fair, and just policies and practice?
Yeah, it's a great question. And I think, I mean, I would answer it this way, which is the communities that this happens to routinely are in the best position to identify the problem. So in the stop and frisk case, we had a lot of information and support from the Legal Aid Society, which is the public defender organization that I worked for back in the day. In the St. Louis context, we first found out about this from the Arch City Defenders, which is a public defender type program that works on cases in St. Louis. And so from their clients, from the people that are subject to this, this is what we hear all the time. And that what public defender offices have to do is to be able to sort of hear these not as individual, this happened to me, but to be able to look again at data to sort of see how widespread is this happening. And then I think particularly for people that live in those communities where it happens, that you can actually add support and validation by talking publicly that this is what's happening in your community. For people that don't live in those communities, you might not even know that it's happening until that it ends up in a headline somewhere after someone filed a lawsuit. But I think it's important for people to understand, again, the values that we're trying to uphold here, that we're fighting for continually, which is the promise of being free from unreasonable searches and seizures, which has changed over time. And rejecting the criminality narrative is really key to that. And so educating folks in your community that says, well, it seems kind of ridiculous that they found the gun on him. So why would the Fourth Amendment all of a sudden make it like there's no gun on him, you can't try him? And the answer to that is because the principle is that if we don't hold the police accountable for the requirements under the Fourth Amendment, then we're back in 1790 where they just come in anytime that you want. And that's not good for anybody.
Yeah. And general warrants was what we're talking about, people, these general warrants to stop you whenever, wherever, and look at anything of yours. So David, you can please feel free to add to that too. And if not, if you want to talk a little bit about the Carpenter case and cell phones too. So I think cell phones is the factor that like really unites all of us. 95% of the people who are middle school and above have cell phones in our country. It's a neutralizer, but also something that holds so much information about who we are and what our beliefs are.
Yeah, and that's a very important point. A little bit separate from stop and frisk, but the irony and actually the reality here is very interesting. As technology has increased, right, and the police each year have new methods of investigating crime. In fact, when I talk to lawyers who have to deal with these cases, I say the legal issues are very complex, But the technology that the police are using is even more complex, and it's up to us to understand what they're doing and why they're doing it. And so, maybe not surprisingly, but in the last 15 years, a very conservative Supreme Court, I mean, this current Supreme Court is about as conservative as you can get, and backing up the police, has ruled in a number of cases that where the police use technology that can look at a person's personal and private life in a very overwhelming way, that is searches of computers, searches of phones, our entire lives. I mean, think about what's on your phone or on your computer, everything about you, medical records, emails, social connections, political beliefs, religious beliefs. As you said, what used to have paper in your house is everything on these equipment. And what the court has said, sometimes unanimously, a very conservative court, and I'll use the phone case as an example, when police arrest somebody, if they have the power to arrest them with probable cause, they can search that person and seize anything on that person that might give them evidentiary value, right? So they can look throughout whatever you're carrying. And so they arrest you, let's say, with probable cause for a drug offense. They seize your phone. Well, they'd like to look into that phone, right? Maybe there are messages on the phone that will prove that you're a drug dealer, right? And that's what they started to do without a warrant. And the Supreme Court a few years ago unanimously said, you cannot do that with phones, you can't do it with computers, you can't use cell site information to determine where people might be for a long period of time. All of that, to use a term that a judge has used, gives the police a complete mosaic of your life. And so the invasion of privacy is huge in that kind of situation. And because of that, the court has said before the police can actually open the phone, look through your computer, they have to convince a judge to get with a warrant, right? And so you're back to the warrant requirement and probable cause. And then, of course, once you do it, how do you do that kind of search? Can you look, well, I'm looking for child pornography on the computer. Can I look anywhere on the computer? Well, it turns out there's technology that can limit the way you search it, which is the challenge, right, to understand that. So it's a whole new era in many ways because of new technology. And the court's been very clear that where technology passes the line, and it's not just kind of some passive incidental surveillance of somebody, but that there's pervasive surveillance. And this could be by cameras, this could be by automatic license plate readers, this can be by cell site information where your phone might be. It can be by reverse Google warrants, where the police send a search warrant to Google and say a crime was committed in a particular area. We want everybody who has entered a Google search for that address previously. Maybe that's why they were there. So as their technology gets greater, the courts have to respond, and there are many, many unanswered questions in that field. But you're right in saying that the Carpenter case and the Riley case, which dealt with that, even a very conservative court recognizes that unlimited police discretion here poses a huge risk to individual privacy.
Fantastic. I know we have to wrap up. We're a little over and some of our people had to jump, but it was a fantastic conversation, really wonderful and thought through, and so much more that we could unpack. I just want to kind of echo the big themes that I heard today is, Vince, great line, disrupt the narrative, the classic constant narrative of more policing, more searches and seizures will create a lower crime rate. Disrupt that narrative. I think something you both said over and over again is follow the money. Where's the money going on these crime initiatives? Who is it going to? And what is the technology they're using? And is that overly invasive and improper? Lived experience, having people that are directly impacted by this, listen to them, hearing their stories and understanding how you can disrupt that narrative and follow the money with your vote as well, with who you're voting for mayor, for law enforcement, all of these pieces. And then the final thing is, and this is, again, as a data nerd myself, respect the data. The data tells us so much about our social context and our social infrastructure. So really rely on that as well. We're going to do a wrap up after this course, share this video out with everybody and link all the different sources of data and all the different cases. But I just want to pause for a moment and thank you so much. Fantastic conversation. What a great way to start the week. I'm just really going to be jazzed all week on this topic. Thank you.
Thank you. And Vince, great to see you again.
Great to see you, David. Great to see you and to hear you. Thank you all so much.
Thank you very much. Thank you, students. Have a great day. And if you have any questions, you just reach out to